everything is sexist.
Texas student commits suicide after Title IX kangaroo court. This is probably going to be a rather more serious everything is sexist episode, but it's an important topic that brings with it an important issue. That being the issue of due process and the issue that colleges and the law seem to come in conflict with quite often. Primarily this idea of listen and believe, and why, while it might be well-meaning and noble, is also severely misguided and flawed within the context of practicing law. But we'll get there. Note, while I have a thorough understanding of the criminal code, specifically the one within my state, and more in-depth understanding of the justice system than your average citizzen, I've been a police explorer for 3 years, and part of my training has to do with the law and understanding police procedure and reading the actual criminal code. I'm not a lawyer, so don't ask me for legal counsel because those are two completely different things. If every other egregious example of a male student denied due process after being accused of sexual misconduct gets ignored, this one should not be. The thing about this case is that it's not technically a case of sexual misconduct. At best, it's a simple case of intimidation, and at worst, if we're applying the criminal code definition loosely, there is a case to be made for a hate crime within the context of intimidation and harassment of a person of another sexual orientation. However, that is a sketchy area of the law, as not all states cover sexual orientation within their hate crimes statutes, and PDs generally prefer not to jump the gun and charge hate crimes, as we all know, with those instances come some rather serious media attention. Not all of it good. However, the details surrounding this case and how it was handled make it relevant to the issue at hand, which is colleges taking justice into their own hands. A male student who was accused of sexual harassment committed suicide just days after the University of Texas at Arlington ignored its own policies in order to punish him. The accused student's father, a lawyer acting as administrator of his son's estate, is now suing the school for violating his son's Title IX rights. College administrators, as well as members of the media and legislators, would do well to remember the name of Thomas Klocke. Klocke, a straight male, was accused by a gay male student of writing anti-gay slurs on his computer during a class. Klocke vehemently denied the accusation, and administrators who investigated the incident acknowledged there was no evidence to support the accuser's claims, yet Klocke was still punished. This is a simple case of he said, he said. In such cases as these, it would be prudent to give the accused the benefit of the doubt due to the fact that a reputation can take years to build and only a few seconds to break down. Such accusations are difficult to prove because they have no actual feasible evidence to them, mostly just witness testimony, and in some instances the only way to gauge the level of validity of such a claim would be to interview character witnesses, friends, and peers of the accused to determine if such an accusation fits a pattern of behavior. Perhaps even, the accused can consent to having his or her messages and such searched in an effort to prove their innocence. A rather invasive mode of investigation, however, remember that the accused would be consenting to the search. Furthermore, in a less privacy-invasive tactic, the investigators could have looked into the accused online activity without the permission of the accused to deem if there was a pattern of behavior. I don't know if this was covered within the realm and scope of the investigation. It likely wasn't, because the whole entire process took such a short amount of time. However, the sentence here that truly and deeply infuriates me is the fact that the administrators who investigated the incident acknowledged there was no evidence to support the accuser's claims, yet Klocke, the accused, was still punished. The accused student, who is being sued by Klocke's father for defamation, claims that in May of 2016, Klocke made a comment during a class about privilege and then proceeded to open his laptop and type "gay should die" into his web browser search bar. The accuser, who is not being named because Watchdog was unable to contact him for comment, claims he typed into his own browser search bar, "I'm gay." The accuser next claimed that Klocke feigned a yawn and said under his breath, "Well, then you're a faggot." The accuser said he told Klocke that he should leave the class, to which Klocke allegedly responded, "You should consider killing yourself." This is where I'm going to take the chance to explain as to why listen and believe is a flawed concept and give examples as to how it's flawed. The simple fact of life, everyone lies. Everyone, and I've said this before, no matter the race, creed, gender, sexual orientation, or whatever, everyone lies for any reason. This is irrefutable and fact, but what happens when we believe a defamatory claim that someone makes regardless of evidence or not? You can ruin people's lives. That's what can happen. Take the Salem witch trials, for example. Extreme example, I know, but relevant. 1692 to 93, of the roughly 200 people that were accused of witchcraft, 20 people were executed. As you can imagine, none of the people accused were in fact witches, and eventually the town of Salem admitted their mistakes and offered compensation. However, the damage had already been done. Once you make an accusation, you cannot take it back. And in the context of such accusations that could possibly end a person's life, or in this case label them as a homophobic bigot and result in punishment that destroys their life and will to live, it is imperative that the evidence is irrefutable, and that you have the person that you should. This is why we have processes and investigations put in place to ensure that you have the right person. The accuser claims he was made so uncomfortable by the exchange that he waited until the end of class and spoke to the professor, who allegedly told him to contact student support services. There is no documentation to suggest the professor was interviewed in the course of the investigation in order to corroborate the accuser's claims. The attorney for Klocke's father, Kenneth Chaikin, told Watchdog The professor never provided a witness statement, suggesting that he was never asked what he saw that day. Klocke insisted that what happened in the mid-May class in 2016 was completely different than what the accuser claimed. Klocke said his accuser made unwelcome sexual advances towards him. Klocke rejected the advances, telling his eventual accuser that he was straight. The lawsuit suggests that this rejection led the accuser to make up his story, possibly out of fear that he himself could be accused of sexual misconduct. Here we get the other half of the story, and unfortunately, because Mr. Klocke is no longer with us, we only have his recorded testimony and cannot further question him as to what exactly happened in May of 2016. Instead of seeking support services, the accuser reached out to Associate Vice President of Student Affairs, Heather Snow, with whom he had a friendly relationship. The accuser was close enough to Snow to refer to her by her first name at times, and Snow quickly became the accuser's advocate, helping him to draft a complaint against Klocke and conducting the disciplinary procedure without following the school's Title IX policies. This is where we get into the meat of the story and what I wanted to discuss. This is where I am disinclined to side with the accuser and the school. There are several things that have gone wrong here. 1. The student did not go directly to support services, but instead went to the VP of Student Affairs, with whom they had a close relationship with. 2. Snow, the VP of Student Affairs, not only allowed this, but also circumvented the typical processes that are put into place. 3. Snow did not immediately recuse herself from the case, as you typically do in the instance of probable bias. Instead, she helped the accuser draft a complaint, and conducted the disciplinary procedures herself. Do you not see exactly what is wrong with that? In a court of law, you are tried by a jury of your peers, and the courts make a conscious effort to ensure that the jury, the court, is as unbiased as possible, in an effort to allow the evidence to speak for itself. Something like this, not following procedure, sets precedent for cases to come, and it speaks to the potential validity of other claims that have been made. It tells us that if in this case procedure was not followed, why not others? If in this case the disciplinary procedures held bias, why not others? It calls into question other verdicts put forth by the school. If the school were at all smart, they would relaunch all investigations immediately, primarily the ones conducted under Snow, because in this instance, she has completely undermined her authority and credibility. The lawsuit alleges that UTA's Title IX coordinator was not informed of the allegations, even though Snow suggested it constituted sexual harassment. This is a violation of UTA's policies regarding sexual misconduct, which states that complaints should be made to the Title IX coordinator or deputy coordinators. Snow was neither. Further, UTA's Title IX policies state that the Title IX coordinator is responsible for overseeing the investigation and assigning an investigator. The investigator must then produce a report based on facts gathered and presented to the Title IX coordinator and deputy coordinator before any hearing. Now, traditionally, in the instance of a Title IX case, and the way it has been done at my school is that the accuser initially meets with the investigators or the support advocate. The accused is then informed of their rights and the accusation. An investigation is conducted, both sides are given time to build a case. Question witnesses get legal representation and the likes. Sometimes a no-contact order is issued to the accused. This is essentially to prevent confrontation of the accused to the accuser and is meant to inhibit intimidation of the accuser by the accused. However, it can also be used to protect the accuser from further trauma. It's essentially a baby restraining order, and the only authority it has is given to it by the school. The thing to remember is that the no-contact order is an option given to the accuser. After the investigation is conducted, the investigator, usually campus police, gathers the facts into a report, gives it to the Title IX coordinator, who then determines the next step. Mind you, none of this has hit the prosecutor's office or seen the light of an actual police detective shield. Everything is held internally within the school. After the Title IX coordinator examines the evidence and determines if there is a strong enough case to stand a hearing, then there's a hearing, if yes, in which the accused is allowed the opportunity to defend themselves, and at the end of which, if the accuser is deemed guilty or not. After that, there is a sentencing process and an appeals process that take place. Keep in mind that this entire process is supposed to take months to hash out. Klocke received no hearing, even though he contradicted his accuser's claims. Had Snow properly reported the complaint to the Title IX coordinator, Klocke would have received necessary protections from the school. By doing things on her own terms, Snow was able to deny Klocke his rights as stated in the UTA policy. Snow took control of a disciplinary procedure that involved a complaint she wrote herself. She enlisted the help of UTA's Associate Director of Academic Integrity, Daniel Moore, and had him tell Klocke he was immediately prohibited from attending the class where the incident was alleged to have occurred. Klocke was completing the course as a part of a short pre-summer semester in order to graduate that summer. When Klocke was informed that an accusation had been lodged against him, he was not told the name of his accuser. Klocke was also informed that he could not contact anyone in the class, directly or indirectly, effectively denying him any ability to find witnesses to corroborate his story. His accuser was able to remain in the class and find witnesses. He found only one who didn't corroborate his account, but did say he overheard someone say, "You should leave." This could have been said either by Klocke or his accuser in either of the stories. Just so everyone knows, I hold Snow entirely responsible for the death of this boy. Had she not engaged in blatant negligence and what I feel comfortable calling nepotism, the boy might still have been alive today. Note this, though. I am not all out siding with Klocke's side of the story. My personal issue is with the irreconcilable disregard of the due process that resulted in this boy taking his life in a case where he might have been completely innocent, but not given the chance to prove it. I'm more than livid, as this is a case in which the odds were completely stacked against Mr. Klocke. From the beginning, he stood no chance. Klocke told Moore he needed to attend the class and ask for more information about the accusation against him. Moore ignored this request but sent Klocke a summon letter on May 20th. The lawsuit alleges Moore never informed Klocke that this was a Title IX investigation, as Moore usually handled academic issues, or Klocke's rights under Title IX. Moore also never told Klocke that he would not be allowed a hearing. He was never informed that Snow, who was not an impartial party, was running the show, even helping Moore determine the punishment. Klocke was charged with violating Title IX based solely on the accusation. He was charged with 2 violations, physical abuse or threat thereof, and not specific violation of the school's anti-harassment. It should be noted that the accuser never claimed Klocke was physical or threatened physical harm. Yeah, let's just tack on some charges like he's a corkboard without even so much as a hearing or evidence or credible, reliable witnesses or anything that's usually necessary. By charging Klocke in this manner, UTA further violated its own policies, which state that charges are supposed to come after an investigation and hearing, and after the accused has had a chance to present witnesses in his defense. The accuser's report, written in whole or part by Snow, was described as a statement of evidence against Klocke. Klocke was not provided a list of witnesses, even though Moore's summons letter said he would do so. Moore's letter informed Klocke that he could be expelled over the accusation, though UTA policy states that the accused students facing such punishments have the right to a hearing, which Klocke was denied. Klocke met with Moore on May 23, 2016. Klocke brought his father, Wayne, an attorney, but was told Wayne could not stay. Moore did not tell Klocke that his father would be allowed to stay if Klocke waived confidentiality. And remember when I said that this entire process typically takes months to hash out? Well, I looked it up, and all this shit started on May 19th, and May 23rd rolls around, and they're already talking punishments without a hearing. That's less than a week. Less than a week! Wayne's attorneys deposed Snow and Moore ahead of filing the lawsuit and received documentation from UTA regarding Klocke's case. Notes from Moore's meeting with Klocke indicated the accused student said he didn't know the name of his accuser prior to the incident and wondered how the accuser knew his name. Klocke also told his side of the story, claiming his accuser sat next to him that day in class and called Klocke beautiful. Klocke said he typed into his browser, "Stop, I'm straight," to which his accuser replied, "I'm gay." Klocke further said his accuser kept glancing at him, so he asked him to stop. He denied fake yawning and said he was the one to ask his accuser to leave. His accuser began typing on his phone and laughing, which Klocke found distracting, so he moved across the room about 30 to 45 minutes into class. Klocke denied typing any slurs into his web browser. Despite learning that Klocke may have been the victim of sexual harassment, no investigation was conducted, and Klocke was not told he should file a report. After the meeting, Moore informed Klocke that he needed to go to a private room to take an exam for the class he was not allowed to attend, since Klocke had not been allowed to attend class in the prior days. He was unaware of some of the test material and thus did poorly. Moore also told Klocke he could continue working on group projects outside of class, but he could not attend the class himself. Moore informed Klocke he would be speaking to a witness and would decide Klocke's fate after. UTA Policy 9 states that disputed accusations and charges that could result in expulsion should include a hearing. Again, Klocke was denied this. Again, we've jumped back to this point that the accused wasn't given the opportunity to properly defend himself, and that just sickens me. Furthermore, the policies put in place to ensure that Klocke received a fair and balanced hearing to determine his innocence or guilt were completely ignored for who knows what reason. We can certainly speculate, but at this point, it sits in your conjecture. On May 24, 2016, Moore and Snow discussed the case. Snow asked if Klocke acknowledged the behavior he was accused of, to which Moore replied, "Not at all." He told Snow the students had completely different accounts of the incident in question, but did not tell Snow what Klocke's story was. Not that it likely would have mattered to both Snow and Moore, who had already made up their minds at this point. Woo! Fuck this article! Moore also told Snow he didn't have enough evidence to keep Klocke out of class. Snow agreed, saying there isn't enough to go off of, and said Klocke should be allowed back into class with a mutual no-contact order with his accuser. Instead, Moore said he would look for another way to keep Klocke out of the class, and Snow told him to see if the class would be offered later in the summer. This, the lawsuit states, effectively confirmed that Thomas not only should remain excluded from the classroom, but that he should be excluded from the course altogether, despite the fact that there was not enough to go off of to keep Thomas out of the classroom. This is something that also pisses me off, because not only did they acknowledge their wrongdoing, but they also conspired to find a way to perpetuate it. Moore reported back to Snow that he worked it out to keep Klocke out of class. Snow said it seemed like a good resolution. I really would like to know exactly what he did to work it out. Moore sent Klocke a letter the next day, on May 25th, stating that Klocke had been found responsible for harassment, even though Moore and Snow acknowledged that there was no evidence to support this claim. Klocke was placed on disciplinary probation for the remainder of his time at UTA, and would have this on his disciplinary record. It was never explained to Klocke why he was found responsible when there was no evidence. So at this point, if I understand this right, and I'm sure that I do, Klocke has been kept out of the loop for this whole process. He's been unable to defend himself properly because he both inhibited his ability to collect witnesses and kept his accuser's name from him, so that initially he could not even begin to imagine who it was he had wronged to formulate a cohesive defense. You did away with the hearing process, completely jeopardized his classroom performance and his future prospects on top of that, and proceeded to punish him in the span of a week for something there was no evidence for. Am I getting that right? This is a tragic situation, and we express our deepest condolences to the family for their loss. The university said in a statement to Watchdog, "The welfare of our students is our highest priority. Any loss is a heartbreaking one for our entire community." The university followed its policies and procedures. This is now the subject of a lawsuit in federal court, therefore we are unable to respond further at this time, the statement said. Apparently not on both accounts. The following the policies and procedures and the caring about your students. Because if you had done both of those things, there would have been a hearing, a chance for defense. But no, all in the span of a week, this man's entire future was stripped away from him on not even a technicality, not even oversight, no, blatant disregard of procedure. Shaken, the attorney that filed the lawsuit, told Watchdog that someone informed Klocke that his disciplinary record could keep him out of grad school, which Klocke had planned to attend after graduation in the summer. This is what I refer to when I say that they stripped Klocke of his future. Just days after Klocke was punished, he took his own life. Had Snow and Moore followed proper UTA policy, Klocke might never have been punished in the first place, as he would have been allowed a hearing to present evidence in his defense. Klocke's father alleges his son was discriminated against because he was a male-accused student, and that Snow and Moore selectively enforced UTA's Title IX policies. Now, we can't know for sure which story is true, Klocke's or the other students. We can't know if this was a blatant discrimination or nepotism, but we do know that this is a case that, had it gone completely unchecked, had Klocke's father not filed the lawsuit and gone down without a fight, this would have set a precedent of behavior that could have happened again within the offices of UTA. Thankfully, there are people such as Klocke's father who have brought to light this issue so that it can be corrected and put under a spotlight. This lawsuit, it will set a precedent at colleges to hold strong to their policies rather than disregard them in the future, and hopefully we can avoid such a tragic outcome. Klocke had no prior history of mental health problems, and by all accounts was happy and looking forward to the future after graduation. In a statement to Watchdog, Chaikin expressed the importance of fair investigation. When a college violates the legal rights of a student accused of misconduct and its own rules for addressing such a complaint, the accused student can suffer life-altering consequences, he said in an email. The important case of Klocke v. University of Texas at Arlington illustrates just how quickly and arbitrary a college can act, leading to the most tragic outcomes from the unimaginable stress and pain that an unfairly treated accused student can suffer. It also serves to underscore why reforms in the campus disciplinary process are so necessary, as recently recommended by the American College of Trial Lawyers, and why accountability through the judicial process may help to promote these reforms. And that's where this story ends. Now, did Klocke maybe jump the gun a bit? Yes. Suicide is never an option. It's a permanent solution to a temporary problem. And I've used that line before in barricaded subject negotiations, where the subject was suicidal or just hopeless, because it felt like the right thing to say to someone who had looked like they were running out of options. And it's a saying that's stuck with me, because it really is what suicide boils down to. If you take away one thing from this video, let it be that suicide is a permanent solution to a temporary problem. But the second thing that you should note, if you find yourself in a situation like this, do not take it lying down. If you are aware of your innocence, become aware of your rights as well. Do whatever you have to do to be heard. Get help. Your parents, in most cases, are on your side and will help you. You have resources. There are a few lawyers who are willing to do pro bono work in cases like these, as they are so important. There are organizations dedicated to making sure that the wrongfully accused are heard. The internet is a hell of a community to start with. If you shout loud enough, you will definitely be heard. The third and final thing that I would like to leave off with has to do with the concept of listen and believe. I mentioned it before. As I said, it's noble. However, it has no place within the law and where consequences are concerned. It's one person's word against someone else's, and I'm afraid that in the case of sexual assaults or harassment, sometimes all you can do is listen and believe, because those instances are more difficult to prove. However, such is the nature of those cases. The best you can do is listen, believe, and learn from these experiences, if that is all you have. Because the moment we decide that word of mouth is good enough to convict is the moment the justice system goes to shit. However, that does not mean that word of mouth is not good enough to investigate. There is a difference, believe it or not. As per usual, if you guys have any stories, anecdotes, anything that you want me to cover that would fit the mold of the hashtag Everything is Sexist series that I am working on, you can email me at Weebo0jones@gmail.com. You can @me on Twitter or on Minds with the hashtag Everything is Sexist. Thank you.